I know you. Hi, everybody. Thank you so much for joining us today. I am Michelle Morris with Consolidated Planning Group, and we've got a fantastic webinar today with attorney Tresi Weeks. We're going to be talking about the Special Needs Trust. Now, a few things before we get started, and I'm not going to take very much time today because I know Tresi has a lot of great information for us. I want to let you know that we do record all of our webinars and we put them on our YouTube channel after the presentation is complete. So if you would like to go back and watch this again or check out any of our other webinars, you can look on our YouTube channel. Now, as you have registered for today's webinar, we collected your phone numbers and email addresses. So you will get an email later on today with a copy of the slides and a link to that to the YouTube channel so you can see this webinar later on today. The other thing I want to let you know, as you can see, we're using the chat box today. We're in webinar mode. That means we cannot see you or hear you. So any questions or comments you have, I would love for you to put those in the chat box and we'll get to as many of those as we possibly can. If we don't get to your question, no fear, because you can reach out to us afterwards and we'll be able to help you out. So really quick, Consolidated Planning Group has been in business for over 30 years. We are a holistic financial advising firm located just outside of Houston, but we serve families all across the United States. It doesn't matter. Most of the clients that we work with are in Texas, but as they move out to other states, we're able to help them. We do financial advising. That includes securities and investments, life insurance, retirement planning, cash flow needs, all of that kind of stuff. But we do it traditionally based on, or let me say, we do it with the thought in mind that your child is not going to be able to take care of themselves, or maybe they're not going to be able to have complete independence or a full-time job. So we plan with the thought of special needs focused planning in mind. Almost all of the clients that we serve have kiddos with some kind of intellectual or developmental disability, and we are extremely well versed in the nuances of those situations. We are members of the Special Needs Planning Academy. We are nationally certified Social Security advisors, and I'm a chartered special needs consultant through the American College of Financial Services. So families come to us for things like protection plans for their families, how to use an ABLE account, how to pay for a lifetime of care, transition planning, and of course, we're here to advocate for you and to educate you because financial advisors are not all created the same, and neither are attorneys. So that's why we have, experts in the field who present to you. Out of the entire United States, there are over 263,000 financial advisors, but fewer than 200 of those truly focus on special needs planning and understanding the nuances and the information that you need to have. That's why we do so many educational webinars to help you. We think that it's very important that you start planning as early as possible so that you have a longer runway to make sure that the future is going to be in the right direction for your loved one. We also want you to think about what's going to happen after high school because you don't want your child just to graduate to the couch. There are great residential options, there are great vocational options and educational options beyond high school. There can be waiting lists for some of these programs, so think about them early. And we always say to make careful consideration before you just assume a sibling is going to be willing or able to take care of their special needs sibling. So today, one thing that we talk about every single day with our clients is the Special Needs Trust. And Tresi is here to help us understand from the attorney point of view everything we need to know about the Special Needs Trust. And there's a lot to know. So I'm just going to step aside and let Tresi take over. I want to thank you so much for being here with us, both to the audience and to you, Tresi, for giving us this time to help you understand and for Tresi to explain. So
Well,
go
thank
ahead.
you. Thank you, Michelle. And the service that Michelle, you and Consolidated Planning Group provide are invaluable. And
Oh,
the fact
thank
that
you.
you are specialized in this is so important. I do encourage people to create a team, a support team of people that are specialized in this area. So thank you for the opportunity to speak today. So, okay, I do have control over the slides now. So
Yay.
so my firm, the Weeks Law Firm, we are in Plano, Texas, but we do special needs trust and estate planning for families all over Texas. Now, if you are not in Texas, what I'm telling you today does apply to you, but the laws are a little bit different in different states. I do have to tell you ahead of time that I am not giving you legal advice for your specific situation. This is just educational in nature. So we're going to talk about a couple of scenarios. Let's see if I can. Okay, there we go. I'm going to go through some scenarios just to illustrate the issues that can come up. And so these are not real people. These are just stock photos, but these are based on real situations. Because of attorney-client privilege, I can't tell you about my real clients. And if you're my client, I am not telling anyone about you. But these scenarios will teach us very valuable things. So let's imagine Izzy. So Izzy is a young adult and she's living with her parents, and she's having a great life. She is receiving SSI, she is receiving Medicaid, and then she also receives Medicaid waiver programs that are paying her mother to care for her, paying for diapers and breathing supplies and all kinds of things. And because of those programs, her parents are able to afford to take care of her at home. And so Izzy has so many activities. She has an online business. She has friends that come visit her all the time. She's just enjoying her life. But her parents were so busy giving her a good life that they forgot to plan for the future. And so, unfortunately, both of her parents passed away unexpectedly without any kind of planning, no attorney involved, no financial advisor involved. Now, her parents were not wealthy, but they had a house, cars, bank accounts, IRAs, 401ks, and life insurance. Because there was no proper planning, it all went to Izzy outright. Now, without proper advice, that money went to her outright. She wasn't able to manage it well because she was not had not had any training in that. But because she inherited it outright, she lost her SSI and her Medicaid. So what happened was that all of the parents' assets had to pay for everything out of pocket. Before her parents died, she had been on her father's health insurance plan, and of course, that went away as well. So the assets that they left to her had to be used for all of her medical. She might be able to buy a policy on the open market, but it may not cover a lot of what she needs. The assets left to her would have to pay for 24-hour care and everything that she needs, and to replace everything the parents did for free. So, as you can imagine, what her parents left her only lasted a certain number of years. So, what happens to Izzy when the money runs out? Well, unfortunately, she could reapply for Medicaid and get that, and get SSI or one of the other programs. But a lot of her doctors didn't take Medicaid. It didn't provide much, and SSI is less than 1,000 a month. So she was no longer able to afford to live in her home. And unfortunately, Izzy ended up in an institution, a state institution. So she lost her home that she grew up in. She lost her friends, lost her business. All of the things that gave her a good quality of life are now gone. In case study number 2, let's imagine Andrew. So Andrew is also a young adult and he lives in a group home and he really enjoys the group home. It's in the town where he grew up. He gets along with the guys that he lives with. He's got activities. He's getting SSI and Medicaid as well. Now, the group home that he's living in costs more than his SSI check. And so his parents have been supplementing that so he could stay in this group home that he enjoyed. His parents saved their money their whole lifetime for Andrew. They knew that they couldn't leave assets directly to Andrew. And so instead, they left it to their daughter, Susan, because they said, our Susan loves Andrew. We know that she would use that money for his care. So the parents passed away and all of their estate went to Susan. Sure enough, Susan loved Andrew. She used that money for him, paid for the more expensive group home. But then, unfortunately, Susan died. So because those assets were in her name, those assets are distributed according to her will or her estate. Now, she and her husband and her 2 kids live in California. And so when she died, she had left her estate to her husband. So what happens is Andrew's parents' money all ended up with Susan's husband and her kids. None of it went to Andrew. And Susan's husband didn't really have a relationship with Andrew. And so none of that money went to Andrew. So now Andrew is destitute. What does his life look like? Well, he can no longer live in that group home because he can't afford it. All he has to live on is SSI and Medicaid. So he ended up moving to a group home that was paid for by the state, but it wasn't in the town where he grew up. It was many miles away. He didn't get along with the guys in there. He lost all of his activities and lost all of the things he was familiar with. So again, his basic needs may have been taken care of, but it's not the life that his parents had saved up for. Now let's imagine Kyle. Kyle is also a young adult and he is living in a group home, getting SSI and Medicaid, and he has a job. And so he works at HEB as a sacker. He sacks groceries in the town he grew up in. And everybody loves Kyle. People will come into this store just to see Kyle. So he's got lots of friends, a joyful life. His dad knew not to leave his estate to Kyle, so he created a special needs trust. And when the dad passed away, all of his assets went into the trust for Kyle. But the dad, when he was deciding who was the trustee, he named his brother, we'll call him Uncle Bob. He named Uncle Bob as the trustee because he was an accountant, good with numbers. But Uncle Bob lived in another state and he didn't really know Kyle. He didn't have that relationship. And so Uncle Bob's looking at numbers. And so he says, Kyle, you've got to move up to my state. And so that's what happened is Kyle had to move up to the state where Uncle Bob lived, which means that Kyle lost his job at HEB. He lost all of his friends, all of his support system, and he ended up living in a state where he didn't have friends. He didn't like the climate, and he was very unhappy. So again, his dad thought he did planning correctly, but it ended up not giving Kyle the quality of life that he wanted. So in all of these situations, these could be avoided with proper planning. So let's talk about what the proper planning is. First, we'll give a brief overview of government benefits. Now, I'm going to simplify this. Um, um, I just be aware I'm simplifying. It's much more complicated. But we're mostly talking about SSI, which is Supplemental Security Income. The maximum check this year is $967 a month. That is to be paid for food and shelter. Medicaid, of course, is basic Medicare, medical care, And then there are the Medicaid waiver programs, and hopefully you're familiar with these, like HCS or CLASS. Some of those, they can pay for attendant care, residential, supplies, therapy, a lot of different things. If you don't have your child on the waiting list for those, you need to do that today, because the wait list is, for some programs, is 19 years long. So hopefully you are aware of that. So for someone to be eligible for SSI and Medicaid, they have to meet two requirements. They must be sufficiently disabled and have low income and limited resources. The Medicaid waiver programs are going to have a little bit different requirements. To be financially eligible for SSI, the individual has to have less than $2,000 in countable resources, and they have to have less than $2,000 in monthly income. So even though the $2,000 is the same, they have to meet the resource limit and the income limit. So monthly income. So if your child is working at a job, 50 cents of every dollar they earn counts as income. So if they earn $500 a month, 250 of that will count as income, and that will reduce their SSI check by 250, which is fine. But if an individual is making more than 1,620 per year, then they actually don't meet the definition of disabled, because then this is what they call substantial gainful employment. Now, if your child is not on SSI but just Medicaid, their monthly income has to be less than $2,000. Now, we know that if your child is working, that's income, but there are also things that are considered income that you wouldn't think about. If somebody gives your child cash, or there's an asset that could be converted to cash. And also, because SSI is to be used to provide shelter, it used to be food and shelter, but they changed that recently, so it's shelter. If someone else is providing shelter, that is considered income. Now, when your child is under 18, the income and resources of the parents is deemed to be that of the child. So for many families, the child is not eligible financially for SSI Medicaid until they turn 18, because the instant they turn 18, the parents' income and resources are no longer counted. Now, in Texas, the SSI check can be reduced by work or things like that, but as long as your child is receiving at least $1 of SSI, they automatically get Medicaid. So for some of our clients, Medicaid is the most important thing. So there are a lot of rules about what income is for Social Security and Medicaid, but they have what's called in-kind support and maintenance. So if someone else is providing shelter, that's considered income. It used to be food and shelter until last year. But for most families, what they do is they take a 1/3 reduction of SSI. Not most families, but some people, there are different ways they can compute how much income that shelter counts as. But typically it would reduce their SSI check by 1/3. But there are ways to avoid that 1/3 reduction. The most common way we see is if your child pays rent. You would enter into a rental agreement with them. They would pay, maybe $700 a month or whatever rent, and then their SSI check is not reduced by 1/3.
Well, I just want to say here that we do offer a rental agreement template to our clients that we have. We usually say, 500 or 600 bucks is enough. Would you agree with that? Just a nice round number that is going to be counted.
Yes, and I've heard recently some parents are charging up to 700 because it affects how much they get from SNAP benefits, the food stamps. So like 600 had been a normal amount, but some people are raising it up to 700 to maximize their SNAP. And I'm not an expert on that, and Michelle, maybe you are, but that's what I'm hearing from some people.
Good to know. Good to know. Thank you.
And great, that's a great resource to have that lease agreement. Now we've talked about income. Let's talk about resources. Your child has to have less than 2,000 in countable resources. So what does not count is if they own a house, a car, their personal belongings like computers and things like that. If there is a 529 education account for their benefit, that does not count. What does count is everything else. So that would be any kind of bank account other than their Social Security account. If you have a uniform transfer to minor account, that's a special savings account for children. Once your child reaches 21, they have a right to that money. So when they turn 21, that counts against them. So when we're working with a family, and I know Michelle's the same, when we're working with a family with an UPMA account, we work to try to maybe get that spent. Also, if there's other investments or real estate. I do want to tell you the government benefits are going to change. When a parent takes Social Security retirement or a parent died and they contributed to the Social Security system, if your child was disabled prior to the age of 22, they will be eligible for the Disabled Adult Child Benefit. That benefit is based on your work record or the parent's work record, and they would get, for example, 50% of that. So if you took Social Security retirement and your retirement Social Security check is 3,000, your child, you would still get 3,000, and then your child would get 1,500. They would have, and because that's more than SSI, they would no longer get SSI. They don't get both. Um, the great thing about this is once they've been on the disabled adult child benefit for 2 years, then they get Medicare. So they should have Medicaid and Medicare. For a lot of our clients, Medicare is the golden ticket because a lot of doctors take Medicare that didn't take Medicaid. Now, in Texas, there are over 40 different Medicaid programs. One of my lawyer friends said they think there's at least 100. But each one has different eligibility requirements. And so when my clients come in, I discuss with them what exact benefits their child is receiving. Um, and if they're not yet on benefits, we just plan for regular SSI and Medicaid rules. Now, keep in mind that Social Security, disability, and Medicare are not based on financial need. So if you are working, so for example, I work, part of my check goes to Social Security. If I became disabled, I can make a claim for SSDI, and that's not based on financial means. The same thing with Medicare.
Tresi, are you seeing the questions that are coming into the chat box?
Yes.
Okay, okay. I don't know if you wanted to address them as we go or look at those
Well, yeah, I
later.
may go to the end, but the one question is the disabled adult child benefit, DAC. If that's more than 2,000, does that affect their Medicaid? No, there's actually a special rule that if your child's income exceeds the limit for Medicaid, excuse me, because of DAC, they will still get Medicaid. So that's a good question. Now, if your child is not yet 18 and you don't know if they're going to need government benefits, I recommend parents do a special needs trust if there's any chance that your child may need benefits down the road, even if they don't need them now. Um, we want them to keep that option open. So your child does not have to be receiving benefits or determined to be disabled by Social Security in order to do a special needs trust. So, what makes a special needs trust so special? So, we know that government benefits are not enough to support our child. Our child cannot live on less than $1,000 in Medicaid. We have something we want to leave them when we pass away. We want to make sure they're taken care of if we pass away. So, we want to supplement those government benefits, but we want them to be able to be eligible for them if they need it. And that's where a special needs trust comes in. The assets in a special needs trust are not a countable resource if it's properly drafted and things are distributed properly. So you could have millions of dollars in a special needs trust. There's no limit, and it won't disqualify your child if it is done right. And then the result is that the funds in that trust are used for your child and it supplements their benefits, but does not supplant it. So, um, well, we'll get into that in just a moment. Now, distributions from a special needs trust. So let's say you passed away, there's money in the trust, your trustee is using it for your child. If they do it right, that distribution for your child's needs is not considered income, but it has to be done right. And this is why I always encourage people, go to a special needs trust attorney, not just a regular estate planning attorney. You want one with experience in this, because if it's done wrong, your child's life may not be good. It may end up like our scenarios. So what is a trust? It's obviously a legal document that we prepare, but when it's for a child with special needs, it's going to be a blueprint for the caring of your child. Well, in the trust, we'll talk about the people involved in your child's care, the money, and create a safety net for your child. Now, qualifying your child for government benefits is not the only reason we create a special needs trust. I draft the trust with flexibility for changed circumstances. So if your child, let's say at some point your child starts working, or there have been medical improvements and your child is able to do so much more, then the trust would operate as a regular trust. So during their lifetime, if they don't need government benefits, it operates as a special needs trust. But if they need benefits, it operates as a special needs trust. But it also provides for the management of the assets for your child, because even if your child will be able to work, um, they may not be able to manage those funds wisely. So instead, we'll have a trustee managing the funds wisely. But also, the trust, when I'm drafting them, will provide advocacy for your child and asset protection. For example, in our example where the parents left the assets to their daughter Susan, and when she died, it went to her husband. Um, it's not protected from anything if it's not in a trust. But if it's in a trust, your child's money is protected from being taken advantage of, protected from divorce or bankruptcy. There are two types of special needs trust. There is a first party trust and a third party. A first party trust is created with your child's assets, or assets that are considered to be owned by your child. So let's say they inherited assets outright, or child support. We'll talk about that in a minute. Or they had their own savings. They could put those assets into a first party special needs trust in order to qualify for benefits. But the important thing about first party trust is it has to have a Medicaid payback provision. So when your child dies, whatever is left in that trust is going to have to go pay Medicaid back for anything they have spent for your child's entire lifetime. So if you didn't do a special needs trust and assets go to your child outright, like in our situation with Izzy, we could create a first party trust, but then if Izzy passes away, that money's going to the government and not who the parents would have wanted it to. Now, a third party trust is funded with assets that were not the child's to begin with. So this is what we do when we're doing estate planning for the parents. So that when you as a parent die, your assets will go into this third party trust. The great thing about third party trust is if you plan ahead, you've got a third party trust. It does not have a Medicaid payback provision. So when your child dies, the money does not go to Medicaid. It does not go to the state. It's going to go to whoever you have named in the trust as a remainder beneficiary. That could be your family. That could be charities or ministries or whatever. You would be in charge of that. So this is why it's so important to plan ahead so you can have a third party trust instead of a first party trust. How does your money get into a special needs trust? So oftentimes when we're doing a plan for the parents, oftentimes your child's special needs trust will have nothing in it until both parents pass away. Now we can have, other grandparents or somebody may have given money to it, or there may be situations where you're putting money into it, but you don't have to put anything into it while you're living. But then upon your death, your will, when we work with a family, we do a will that says, so my husband and I have one daughter, Jordan. So our will says, we leave everything to our spouse. And if both of us pass away, the assets go into Jordan's trust. Life insurance is a great way to fund a special needs trust. And this is where Michelle and her team are great resources for this. You would name the special needs trust as a beneficiary. So again, for my husband and I, we would have each other as our primary beneficiary, and then Jordan's trust as the contingent beneficiary. And the same thing with IRAs and 401ks. Those are distributed by beneficiary designation, and you can name your child's trust as a beneficiary. And also gifting, we've had situations where grandparents or other relatives want to give something to your child. This is a great way to do it. This shows the funnel, and this is when your trust is funded upon your death. Assets from your will, life insurance, and retirement will funnel into the trust. Now, if you have more than one child, when I work with a family with more than one child, we have a discussion about how much you want to leave to each child. Because I have some clients that leave everything to the special needs trust and nothing to the other adult children, or different percentages, and every family is different. So we customize it for you. Also, Michelle and her team can help evaluate how much you need for your child's special needs trust, to know how much money you're going to need in it, what percentage of your estate you might want to leave to that trust. Now, IRAs and 401ks, this is huge. So if you leave your retirement accounts, and again, if you're married, you're going to leave it to your spouse. But when it goes to the kids, if you leave it to your non-disabled kids, they are now subject to a 10-year payout, which means that when they inherit your IRA, they have to cash it out within 10 years and pay income tax on that. But for people who are disabled, they're not subject to that 10-year payout. They get a lifetime stretch. That means that your IRAs will grow tax deferred for your child's lifetime. They will have required distributions, but they would be based on your child's age according to the IRS single life chart. So this was just a chart. Again, your IRAs are probably not $1 million, but for this particular family, it was combined $1 million. This was assuming a rate of return of 6%. And you can see that that $1 million grew to about $5 million. And so the light green on the top is the required distribution. So the distributions are small at the beginning and then grow. Your child will pay income tax on the distributions, but your special needs child, the distributions are spread out over 30, 40 years instead of 10, perhaps, and they're going to be in a lower income tax bracket than your other children. Now, so this all sounds great, but we can't name your child outright as a beneficiary because this obviously would disqualify them. So when I draft a special needs trust, I add specific language so that it qualifies for that tax deferred growth and it has the IRS requirements. So this is tremendous. And so honestly, a lot of my clients, unless they've got, minor kids they're taking care of, a lot of them are leaving all of their IRAs to the special needs kid and then maybe non-taxable assets to the other kids. So, so this is huge. And this is, again, why it's important to have a customized plan for your family because everybody is different.
The question in the chat box, is that for Roth IRAs as well? All kinds of IRAs?
Well, the Roth IRAs, you're paying, it's different because there's, they're not going to be paying income tax because you've already paid that. So
Thank you.
now let's talk about child support because this is huge and a lot of people are not aware of this, is that Texas law allows child support to be ordered for the lifetime of a child who is disabled, who is not able to support themselves. But you need to be aware that Social Security and Medicaid count that child support as income from the date your child turns 18, regardless of whose name is on the check. So, for example, if a parent is ordered to pay $970 in child support, that's more than your SSI check. So your child would lose SSI and lose Medicaid. And I've had this happen where a child had to have Medicaid to survive, and the child support was higher than SSI, and they lost all of that. So we were scrambling. But there's a way to avoid this. The way to avoid this is we create a first party special needs trust because it's considered your child's asset. And then I work with the family law attorney so that we have the court order, the decree, and it says that that child support is paid into a first party special needs trust. Then it does not count as income to your child for SSI and Medicaid purposes. And then typically the parent that, for example, if the child's living with one parent, that parent is the trustee and they would use that money up each month. So they still get that money for their child's care, but they still get SSI and Medicaid. So this is huge. Let's say that you passed away and there are assets in the trust. What can those trust funds be used for? Well, there are certain things that it cannot be used for. Your trustee cannot give cash to your child because that's considered income. That could disqualify. I advise people not even to use a debit card because that might be considered cash. We also, if the trustee uses it for something that government benefits pay for, that could reduce government benefits. But really, the trust can be used for everything you would have used money for. So all of their essentials, personal needs, social, recreational, entertainment, education, therapies, everything that they need. I even tell people, furniture, mattresses, TVs, but also just all of their essential things that they need, their food, supplements and things, medical. So how does your trustee pay for these things if they can't have a debit card, they can't give your child cash? Well, there's a certain credit card that a lot of our trustees use. It's called a True Link credit card. And you can look this up at truelinkfinancial.com. And it's like a preloaded card. And so the trustee, let's say that the trustee wanted there to be $500 for your child for miscellaneous expenses, going out to eat, getting their hair cut or whatever. The trustee would load $500 from the trust bank account, load it onto the TrueLink card, and then either your child's caregiver or your child, if they're able to, would use that money. So your trustee can pay for things directly. If your child's living in an apartment, your trustee can pay that directly. But then they can use this TrueLink card for all of this miscellaneous expenses, and it works really well. Now we've talked about this trustee. Who is going to be your trustee? Because you get to choose. Well, this is what your trustee is going to do, and especially this is important after you are deceased. Your trustee is going to make sure the money is invested properly, and then they're going to use that money for your child's care. Your trustee is going to be the one to decide whether this is a good use of the money or not. They're going to be saying yes and no. They have to keep good financial records. They're going to have an accountant file a tax return. So being a trustee is a lot of work. And I know we had some people issued some questions or sent us some questions before the seminar. One question was, what about siblings? So, people ask, should we name our other child as a trustee? In some cases, that's fine. And in some cases, it's not, because it's a big burden. And whether that's appropriate for your other child or not varies depending on the child. So it can be a family member, it can be friends. They can hire the assistants they need to advise them. So like when my clients pass away and then there's a trustee, I put them through a 1-hour trustee school where I teach them how to administer the trust. And then there are also corporate trustees. These are trust companies that specialize in special needs trusts. And these are good for trusts that will ultimately have a significant amount of money, at least $500,000. The corporate trustees are experts at making distributions without affecting your benefits. They know how to work with a special needs child, but they do charge a fee, and that fee varies, but it can be typically about 1.4% of the trust assets per year. So for some of our clients, they choose this because they don't want the burden on family members, or they don't have family members that would be appropriate. Also be aware the ARC of Texas has a master pooled trust, POOLED, that also can serve as a trustee for smaller trusts. Now, when I'm drafting a trust, let's say my clients want to name a corporate trustee to act when the parents pass away. Well, I'm going to ask my clients to name a trust advisory committee. They would name 3 to 5 people that would serve after after the parents are gone, that would serve as a support team for their child and advocate to that corporate trustee. Also, we would give the trust advisory committee the power to hire and fire that corporate trustee, because if they're not doing a good job, they can name a new one. What happens if you don't have a special needs trust? So first, let's talk about what happens if you die without a will. The laws of Texas say where your assets go to upon your death if you don't have a will, and it's probably not where you think it is. So not a good idea to have no will. But what if you decide to leave nothing to your child and leave everything to your other kids? If you leave nothing to them, all they'll have to live on is SSI and Medicaid. So less than $1,000 a month in Medicaid, and that's not enough. And I do want to insert here that we don't know what government benefits are going to look like years from now, because Congress can change these. And so we have no idea. So we want you to be able to provide for your child regardless of what government benefits will be available. You also don't want to leave assets to them outright. And if you pass away without a will and without planning, those assets go to your child outright. If it goes to them outright, they could either lose all their benefits, or they could put it in a first party trust that may end up going to the state. So all the money you've saved may end up going to the state. You also don't want to leave the assets to other family members, like we saw in our scenario with Sister Susan, because when she died, the assets went to her family instead of to Andrew. If you leave it to other family members, the money's not protected. And I have people want to do this all the time. And it's, if you leave an example to your daughter Susan, if she gets sued for an accident, that money could be lost. If she files bankruptcy, that money can be lost. If she gets divorced, she develops a gambling addiction, whatever, it's not protected. So please do not leave assets outright to other family members with the intent that they use it for your child. So for most families, you need a third-party special needs trust. What else do you need? Well, you also need a will, so that your assets would go to, that directs those assets to the special needs trust. So again, for my husband and I, our will leaves our assets to each other, and then after we both pass away, to Jordan's trust. Also, if your child's a minor, or if your child as an adult will need a guardian, I want you to choose who that person is. And so we do a document in which you state who would be your child's guardian if both parents pass away. When we work with the family, we also assist our clients in changing their beneficiaries for IRAs, 401ks, life insurance, and those types of things, to make sure that your child's special needs trust is named properly. We also give a letter to our client to give to other family members. So if grandparents, for example, want to leave something to your child, we give them the language that they need. They give that to their attorney, and they can update their will or their beneficiary designations to leave assets to your child's trust. But we're not just planning on if you pass away. We also need a plan if you become incapacitated. And so we do powers of attorney for the parent. So people have legal authority to take care of things if you are in the hospital or whatever. Because as parents, we're not we don't have any magic button that keeps us from being incapacitated, just because of a special needs child. So as you can see, this is a holistic approach. Just having a document that says special needs trust is not enough. We need all of these pieces to work together. Now let's talk briefly about ABLE accounts. Most of you are aware of them now. It allows your child to save up to $100,000 without affecting their benefits. But be aware, and a lot of parents aren't aware of this, that ABLE accounts have a Medicaid payback provision. So if you're saving money in this account and there's $100,000, if your child dies, you just made a donation to the state. It's going to them. So we'll skip through some of these because most of you are aware. You can put in up to $19,000. It has to be used for disability related expenses. But when the ABLE account is used, that doesn't count as income, even if it's used for shelter. And SSA may want to see the records of your ABLE account. Again, that Medicaid payback is a major drawback. Now, but there's one advantage I want to tell you about is if you have a 529 education account for your special needs child, you can roll that over into an ABLE account. When do we use them? If your child has their own money or they want to save, let's say they're getting close to that $2,000 limit, they don't want to use it, they can move that over into an ABLE account. We've also used it for small gifts and inheritances, so under $19,000 a year. Also, if they're living with someone else, you can actually pay rent through the ABLE account in some situations. But I want to caution you on two things that people have thought is they think, let's say your child is working, they think that you can have that paycheck go into the ABLE account and then it doesn't count as income. That's not true. It still counts as income. Also, some people have tried having child support going into the ABLE account. Still counts against your child. So don't do that. We've seen a lot of misinformation about that. So when do you need to create a special needs trust? Well, you need to do it before you die or become disabled yourself. We don't know when that is. And so I found with our clients that the sooner the parents get it done, the sooner they have peace of mind. Some people think the age is related to when you go get guardianship. It's not related. If you want to do it at the same time, that's fine. But I had some parents come in with a newborn that was born with disabilities and they're doing special needs trust. I have some clients coming in and they're in their 70s and doing a special needs trust for their child for the first time. But we're all about providing you peace of mind and like working with Michelle, with your attorney. It gives you peace of mind to have that plan in place so you're not stressed about it.
Well, and life is so quick, as we've seen with the flooding. And I lost a personal friend of mine this past weekend, not related to the flooding, but one night we're out celebrating the 4th of July, and the next morning his wife finds him. So you
Mhm.
never know when stuff is going to happen, and
Right.
it's so fast. And planning now is so important.
It is, Michelle. I'm sorry about the loss of your friend.
Yeah, thank you.
So what's the result if you do this right? You're going to have a financial plan to pay for your child's care. You're going to have a support team in place. I find that when clients have financial advisors like Michelle, it makes it so much easier in the transition. You're going to have instructions for your child's care. They're going to retain the option to be eligible for government benefits if they need it, but the result is just a better life for your child. Now let's go back to our scenarios and see what would happen if the parents had planned properly. If you'll recall with Izzy, her parents did no estate planning. When they died, everything went to her outright. She lost all that money, had to pay for all of her care out of pocket. The money ran out after a certain period of time, and she ended up in an institution. But what if her parents had created a third-party special needs trust for Izzy? Their will left assets to that trust. They named the trust as the beneficiary of their life insurance and retirement. What that means is when the parents passed away, The trustee would then use the money for Izzy, but she would still get the Medicaid programs that were paying for attendant care, diaper supplies, all of that. So what the government benefits paid for, plus what her parents paid for, was sufficient to give her a good quality of life. So she could have chosen where to live if she wanted to stay in her home or get a condo with a friend, whatever. She would have choices and she wouldn't have ended up in an institution. Now, with Andrew, remember that his group home cost more than his SSI check, but his parents wanted him to stay there. What if, instead of leaving the assets to Sister Susan, what if they'd left it to a special needs trust and then named Susan as the trustee? That way, when the parents died, the money would have been in trust. Susan would have used it for Andrew, but then when Susan died, instead of that money going to her husband, it would have stayed in the trust for Andrew, and the parents would have named a successor trustee to step in if Susan wasn't living. So Andrew could have stayed in his group home, continued to have the great quality of life that he had. Now with Kyle, remember his dad had a special needs trust, but his Uncle Bob was the trustee in another state, who didn't know Kyle and moved him up to his state, and it was just Kyle was extremely unhappy. But what if in his special needs trust, the dad had named a trust advisory committee? This could have been a group of 3 to 5 family members or friends here in Texas, who were a support team for Kyle, and they could have advocated on behalf of Kyle to the trustee and said, no, we want Kyle to stay here with his job at HEB with all of his friends, and we'll make sure that he's taken care of and that happens. All right, so again, just a reminder that the information I've given you is not legal advice. This is just general education. Thank you for the people that had questions before, that sent in questions early. One question was reporting the special needs trust. Once money goes in the trust, you have to report it to Social Security and Medicaid, usually within 10 days of the money going in the trust. So please be aware of that. When I'm working with my clients, we help them to do that. If your child moves to another state, your special needs trust is valid in every state, but the government benefits are different in states. Trust law is different. So they may need to do some kind of amendment or change if they go to another state. Michelle, should we take some more questions?
Yeah, there are some more great questions in the chat box. If the parents have died and the special needs child is living on their special needs trust, then that child dies. What happens to the money left over in their trust?
Yeah, so you as the parent actually get to choose who is going to inherit that. So in the trust, it will say where those trust assets go when your child passes away. So that could be your other children, could be other family members, it could be ministries or charities. You would make that decision.
Okay, okay, great. Now, there's a lot of questions about Social Security retirement benefits and SSI and SSDI, and I just want to let everybody know that, we do these webinars 2, 3 times a week and answer all of these different kinds of questions about benefits. So survivors benefits, how does SSI versus SSDI work, all of that kind of stuff. So, one question that I've seen a couple times that you can answer, Tresi, is what happens to the Medicaid if they get survivors benefits or RSDI that is over $2,000 a month? It's over the Medicaid limit, but will they lose the Medicaid or their benefits?
So you will get a letter from Medicaid saying that they've been knocked off, but you just contact them and you'll be able to get back on Medicaid. So if the only reason they're over the income limit is because they're getting disabled adult child benefit, or SSDI, then it's called the Pickle Amendment that allows your child to still be eligible for Medicaid, and then after 2 years, Medicare.
Fantastic. I'll take this one. Our child is currently 9 years old. Do we start the process for SSI now? What if we don't meet the income requirements? Are there other benefits available? So yeah, typically families won't or children won't qualify for SSI until they're 18 years old because when they're a minor, the Social Security Administration looks at the parents' assets and income. So if you have more than $2,000, more than one house, one vehicle, and you're making more than the substantial gainful amount, which is $1,620 a month, then your child won't be able to qualify for SSI. Now, when they turn 18, they're going to look at the child's assets and income only, not yours anymore. And at that point, they should be able to qualify. Tresi, can you talk a little bit about the reporting requirements? And do you need to get a tax ID for the trust? Um,
Yeah,
and what if,
let's talk about the tax ID for the trust. Is that the third party trust as a parent, if you're putting your money into it, it's considered a grantor trust and you don't get a tax ID number for it. But if someone else puts money into it, we do get a tax ID number. And then when you pass away, we would get a tax ID number for it. And then it's taxed as a non-grantor trust. But there are, and Michelle knows all these rules, but there are ways to trusts are subject to the higher limit of the tax brackets early, but there are ways to reduce or minimize the income tax on those.
so we know that 2901, $2,901 is the magic number for income for receiving Medicaid benefits. Is that right? What if they go above the 2901? Um, they're above 300% of the SSI amount, and that would, on survivor benefits, would that kick them off of the Medicaid, or would the Pickle Amendment still protect them?
Yeah, the Pickle Amendment would still protect them.
Exactly. There you go, Karen. I think that's about, do you need, oh, two more questions and then we'll wrap it up. First of all, do I need separate special needs trusts if I have more than one child with a disability? And then the last question that I would like for you to go over is how much does all of this cost?
Yeah, so first of all, there was a question earlier before the webinar about can you just have a special needs trust language in your will, or should you have a standalone special needs trust? You can do it in the will, but for me, the best practice is to have a standalone trust because some retirement companies won't distribute assets to a trust that does not exist yet, or they won't let you name a trust that doesn't exist yet if it's in your will. So if it's in your will, it's okay. It's just not optimal. I prefer having a standalone special needs trust. Um, when we have two special needs kiddos, typically I recommend two separate trusts. And here's why, is that we have to report this trust to Social Security and Medicaid. They are going to review it to see if it meets their qualifications. They like to see that there is just one beneficiary, a sole beneficiary of the trust. So I draft trust with that Social Security worker or the HHSC worker in mind, and I want to satisfy them. So having it in separate trusts makes it easier to get it approved by the government agencies. So I prefer it. We've seen some where we had two in one, but it confuses the Social Security and Medicaid people, and I don't want to confuse them. I want to make it so clear to them that this qualifies, that it's easy. So let's talk about cost. Every attorney is different. For us, we're going to do a third-party special needs trust for our clients. The will, if you're married, it would be you and your spouse, your powers of attorney, declaration of guardian, a lot of other documents, and then assistance with beneficiary changes. So again, the fees are going to vary by the law firm. It also depends on the complexity. Some of our clients also do a revocable living trust for themselves. But typically you're looking at At least, again, I can't speak for all attorneys, but I'd say at least 5,000 for the package. Typically, you're looking at probably closer to 7,000 for that. And there's some attorneys that charge a lot more. There are some attorneys that charge less. Just make sure you go to one who is experienced in special needs trusts.
Yeah, that is so important. Now, we at Consolidated Planning Group offer a free consultation. I saw one person's meeting just come through who I know is in here. So thank you very much, Irma, for scheduling that. Um, if anybody else would like to schedule that free consultation, we would love to have you. We're going to answer any questions that you might have left over from today's webinar or any questions about special needs planning that you might have. We're going to learn a little bit about you and your family and then tell you how we work and what we do and what we can do to help you. This is our entire team at Consolidated Planning Group. Don't forget, we can work all across the country, all across Texas, and we are here to help you. We don't charge anything for this free consultation. It usually takes about 30 to 45 minutes over Zoom. And like I said, we're here to help. Last question, it's 101, and then we're going to get out of here. If you have a guardian designated in your will, does the designated guardian have to reapply for guardianship, or does it just transfer over?
Yeah, so for guardianship questions, so my law firm, we're in Plano. We have 3 attorneys. We do a webinar every month on guardianship. It's
There you go.
free. You would just go to our website. It's Weeks Law Firm. I'll just put it in the chat box. Weekslawfirm.com, WEKS. You just go to our website, sign up for that webinar. Again, it's free. It's 1 hour. It answers a lot of your questions about guardianship.
Fantastic. So I'm going to go ahead and stop the share and just say goodbye, everybody. Thank you so much for taking the time to be here with us. And thank you, Tresi, for presenting all of this great information because, as always, it's so needed and so helpful. And we really strive to be helpful. So thank you for being here with us today.
Well, thank you, Michelle, for the opportunity. And I agree. Thank you, everyone who attended today. Hopefully this gives you a little bit of peace of mind.
Yes, absolutely. So if you have more questions, feel free to reach out to either one of us. I'm with CPG, the financial side. Tresi is with Weeks Law Firm, the paperwork and legal side. And together we will help you and be able to help support your family. I hope you're having a great week and we hear from you soon. Thank you. The slides will be coming out later today. Have a great afternoon, everybody. Bye-bye.
Bye-bye.